Good day, Crime Talk aficionados. This is Scott Reisch, and it is Saturday, and we are doing a live edition here today. We have captioned it Ask Scott. So we have come up with lots of questions that we get asked in the comments section, but we'll also take questions that people ask in the live feed over here as well. We'll try to get to as many as possible, and we'll see how it goes. Sometimes these things can veer right or left on a tangent. But before we do that, there's two cases that I just want to mention. The first one is definitely in the bizarre and weird category. And that is a case out of Michigan, Shawnee County, Michigan, where there a man accused of killing a 25-year-old Michigan man named Kevin Bacon was due back in court. And it is alleged that they've arrested a Mark Latinsky in connection with Mr. Bacon's death. Now, detectives said they went to Latinsky's home to perform a welfare check, which was the last location Bacon was believed to have been. Apparently, this was some sort of dating app, Grindr app. And when they entered the home of Mr. Latinsky there in Michigan, they found Mr. Bacon hanging naked from the ceiling. And according to the detective, Latinsky confessed to killing Bacon by stabbing him with a knife in the back and then slitting his throat. He also admitted that he wrapped a rope around Bacon's ankles and then hung him from the rafters of the ceilings. And then, for those who have, children in the room, go ahead and cover their ears. According to the documents, Latinsky then admitted he used the knife to cut off Bacon's testicles and then consumed them. Obviously, the Bacon's parents are a little shocked and in belief, and I don't know if we can put this picture up, but this is apparently some Grindr app, and these two are going to meet for something. But this guy looks like a total mountain man with a beard down to about mid-waist. Why this guy's spidey senses didn't sense that something was wrong and run, because apparently the police had been called to Mr. Latinsky's home previously, where a man in a leather kilt left the house covered in blood and running. There were no charges filed because apparently no crime had been committed. But what the hell, people? I mean, you simply cannot make this stuff up. And that's, I saw that story last night. And then another one, I just got to share this. I was looking at the news last night, and you just can't make this stuff up. So a man, this story comes from Oregon. A man high on meth fights off 15 police officers, all while masturbating. Like, what the hell? So it says, this is from the Huffington Post. A man who was allegedly high on meth reportedly fought off more than a dozen police officers while publicly masturbating. Andrew Fry, 37, apparently made a series of outbursts and then began masturbating in an Oregon restaurant. Incredibly, police were reportedly unable to subdue Fry with a taser. It took 15 officers finally to take him into custody and stop him from pleasuring himself. What the hell? I mean, seriously, you can't make this stuff up. Exactly. Sounds like Tuesday night. I mean, seriously. Wow, seriously. I don't know. Maybe it's something in the water up there. I don't know. But maybe it's because they don't get to pump their own gas. Last time I was in Oregon, they still don't get to pump their own gas. What kind of state doesn't let people pump their own gas? Anyway, let's see. Here's that Shelley Watson comment in Portland. I see that at least once a week. That's true. All right, so let's take a look. Donna Shepard, he probably likes the taser. Jack the Zipper, you mean? Like I said, if you can't laugh at this stuff sometimes, it really, it would make you cry to think what the hell is going on in the world. Uh, anyway, let's take a look at some of the questions that we get asked. Oh, here's one. We'll just start off. Do you have any children? Yes, I have 2 children. I'm very proud of my children. My son is a pilot in the Air Force, and my daughter is becoming a nurse practitioner, and she's in graduate school at Vanderbilt. Scott, can you explain a little bit more about voir dire and why it is so important? I recently had jury duty and went through voir dire. This person ultimately wasn't selected. This is Susan. Some of the questions both attorneys asked seemed odd to me. It was a citizen contesting a DUI given to him by a state trooper. All right. Jury selection is the most important process in the jury trial. The case is generally won or lost right there. Obviously, nobody comes to jury duty in a complete vacuum, and people bring their life experiences. And so the question is can they set those biases aside that they have and listen to the evidence fair and impartially and giving both sides a fair shake? And then they have to be able to follow the court's instructions, to follow the law. And in voir dire, it would be a heck of a lot easier if you could give all the facts of your case and say this. For example, this case the question was relating to a DUI. It would say, wouldn't it be? Do you believe that the machines are accurate all the time, or the officers are? Sometimes they can screw things up on the test. Who knows? But you can't pitch the specific facts of your case in voir dire because you're not there to pitch your case. You're there to see if they can be fair and impartial. So oftentimes you have to ask questions about other. You have to look for the same thing via different stories being, little anecdotal type of stories. One of the questions that I think is always highly effective, and I use this quite a bit, is usually when I get the guy, on the jury that is, I find him. It's not hard to find. There's always that one guy that, if that guy is sitting over there, he must be guilty of something. All right. Well, I can't just come out and say, sir, because both sides, remember in voir dire, you're trying to get, the prosecution's trying to get rid of jurors that are going to be, they think are favorable to the defense, and the defense is trying to get rid of people that they think are favorable to the prosecution. And in reality, you're only stuck then with people you're not really sure what the hell they're going to do. And you want leaders sometimes. You're looking for leaders. And then you have what is referred to, or at least I refer to them sometimes, as plant life. Plant life will go whichever way the rest of the jury is going. They're just kind of there. But you want to have the jurors that are true leaders hopefully buying for what you're selling. But like, for example, the presumption of innocence. Everybody thinks, a client must be guilty of something. Yeah, no, it's not that difficult. Cops show up to a scene. They say, you know what? I don't care. All I know is somebody's going to jail tonight, and that's it. All right? So to discuss the concept of presumption of innocence, because you want to say, hey, can you give a defendant a presumption of innocence? So I use an example. I usually find it's usually an older gentleman. I don't know why it is, but, he's just kind of a little curmudgeon, and he's sitting there and, he's probably guilty of something. So I simply say, sir, let me give you a hypothetical. Let's say, for example, you're married. And how long have you been married, sir? Oh, you've been married for 35 years. Wow, so you probably know your wife really well then. I do. Well, what time does she usually return home from work? Well, she arrives like clockwork every day at 6 p.m. after she leaves. Okay, so let me give you a hypothetical, sir. You arrive home. Your wife doesn't arrive home at 6 p.m. So you figure, maybe there's a little bit of traffic. So maybe by 6:15, you then are getting a little worried. So maybe you call her cell phone when there's no answer. And then you are getting a little more concerned as time goes by, and you start calling maybe the office, or you start calling a friend to see maybe she stopped and had a drink or after work. Who knows? But by 7, 8 o'clock, you're getting a little worried. You maybe even now calling the hospitals to see if somebody is, maybe been injured in an auto accident, something to that effect. And then by 9 p.m., you're worried as heck, and all of a sudden you get a knock on the front door, and you open the door thinking, it has something to do with my wife, and there's a couple of nice gentlemen there, and they said, "Hi, we're from the FBI." And well, can I help you? "Well, sir, we'd like to talk to you about your wife." "Oh my gosh, is everything okay?" "Yes." "Well, what happened?" "Sir, we've just arrested your wife for robbing a bank." And then I ask this potential juror, what is the first thing that went through your head when the police accused your wife of robbing a bank? And he says, "Wow, I don't believe it. She would never do a thing like that." And I say, "So you would afford your wife the presumption of innocence in that particular scenario, wouldn't you, sir?" "Well, of course I would." "Well, she's been accused by the government, but yet you're still saying you don't believe it." And so the question is, as potential juror, can you sit there and give the defendant the presumption of innocence as he sits there? Just like you would say, "I don't believe it. They're allegations. I haven't heard any evidence. I don't believe it." So that's why the jury process is so important. And you can't just go and say, well, sometimes you can. Can you give my client the presumption of innocence, and sits there and they say no? But it's better you have limited time in voir dire, so you need to educate the jury as well and enlighten them. You have to remember, most jurors have no idea regarding the presumption of innocence. They have no idea about the right to remain silent. They hear about it on TV, but they don't really understand what it means. So you can't pitch your case, so you have to try to educate them and find people that are basically going to be open-minded and listen to the evidence throughout the trial. And so that's why it's the most important part. If you get a jury that doesn't care, not going to listen, it doesn't matter. You can have the greatest case all day, but if they think your client's guilty or they think he's innocent, either way for the prosecution, it doesn't matter. So, all right, next question. Let's see. Do you think anyone will be brought to justice in the Jeffrey Epstein case? Well, turn on the demonetization at YouTube. Since we mentioned Epstein, we might as well mention Weinstein as well. But yeah, no. I mean, let's face it. There are lots of people out there that think Jeffrey Epstein did not commit suicide. We have brought you some evidence that's been released regarding the photographs of the cell, his neck from the autopsy. And I think that it is, I don't want to sound like a conspiracy theorist because really I'm not. It's not about there's a difference between belief and knowledge. And there's a difference between what you know and what you believe, obviously. And usually if you know something, you can be able to prove it with hard, sustainable facts. But when you have somebody like a Dr. Bodden, who is hired by Jeffrey Epstein's brother, who has looked at the evidence and says, I cannot rule out homicide, it really makes you wonder, given the information that we have about the company that Mr. Epstein kept, very powerful people, and the bad things that he was doing with young girls, with these very powerful people, it truly makes one believe that a lot of people did not want to see Mr. Epstein go to trial. But can I prove it? No, not yet. Will anyone be brought to justice? Well, probably the Bureau of Prison Guards who didn't, follow their routine and their procedures, going around and checking the cells every hour instead of just writing it in. But other than that, probably not. I don't think anybody at the prison's been fired. The head of the BOP, the warden there, probably hasn't been fired. It's the government. How difficult is it to fire somebody in the federal government? You have to work pretty darn hard to do that. But everyone at the top will blame somebody else down below. But the guy at the top should probably be the one that takes the hit because they are the ones that are ultimately responsible for what takes under their charge. And if it's great, they get to take the praise and the glory, spread it around. But if things go bad, they're also the ones that have to take the fault and quit their job or resign and get fired and move along. It's called being in charge. It's called being a leader. Let's see here. Anything coming up here that we need to, any great questions that are coming up?
I had one question that was pretty good. It said, do you believe that criminals who commit first-degree murders or those who commit sex crimes can be rehabilitated?
Questions. Do you believe those that have committed first-degree murder or sexual crimes can be rehabilitated? That's a very interesting question. The first-degree murder, I think there would be less. A person would generally be less likely to recidivate on a murder case, depending on the circumstances. Now, obviously, if he's meeting people on Grindr and removing body parts and consuming them, there's not a whole lot of redeeming qualities at that particular person. I mean, there's more than likely some very serious mental health issues. That's interesting. The sex crimes, particularly against children, those are the type of cases where it is much more difficult because you cannot basically turn off those impulses. And there's been a big change in this as it relates to sex offenders. So, for example, here in Colorado for years, the book, which was the guidebook for sex offenders, how they needed to be treated, the first paragraph said a sex offender cannot be treated. They can only be monitored. They only removed that paragraph a couple of years ago. And the problem with that particular classification was they were lumping everybody the same. Someone who was allegedly doing something with children, somebody who, drags a woman in off the street and sexually assaults her and throws her in the dumpster, was treated the same as the guy that, was 19 and his girlfriend was a couple months shy of legal age, and the parents wanted him charged, or the guy that gets a little drunk and grabs the waitress's butt at Hooters or something, gets prosecuted and has registered as a sexual offender. So I guess ultimately the question is, who knows? We've represented lots of people over the years of murder and sexual offenses. We've also represented people that have been falsely accused of sexual offenses. It's one of the more easy. That's really good English there. Yeah, it's a lot easier to make that allegation. Particularly see it in cases where they don't like somebody. But yeah, that's an interesting question. But the question is, I don't know. I mean, past performance is indicative of future results. And so, somebody has a pattern of bad conduct, it's more difficult for them to change it just overnight. When it comes to violent crimes, there's been a lot of studies out there that, if somebody's committing violent crimes as a young person, really the only thing that's going to stop them from committing violent crimes is age. Basically, people they get too old to commit crimes anymore. And that's why you see a lot of lengthy sentences, obviously, on violent crimes, is because basically the statistics show that really the things that slows people down is just simply they get too old and too tired and they don't want to be, they don't want to be there. Let's see here. Carol, why don't they just castrate them and chop off their arms in 1,000% proof? Well, that a technique. That is a technique. Let's see here. The Dulo case. The Dulo case. Let's briefly talk about the Dulo case. The only one that still remains in custody is Dulos's former attorney, his civil attorney, who was apparently there during this conversation out of the gun shooting club where they were talking about a pit that was there with some lime and some tarps and things of that nature. And the police went back and they did did not find anything of evidentiary value relating there. But if everyone's ever been to the woods up there in the Northeast, it is so thick. There's no, it would be so difficult to find somebody. And then when the leaves fall in the fall and winter, good luck trying to find a body up there if that's truly what happens. The vegetation is just so thick, and I just don't. We'll see how that goes. I actually received an email yesterday from somebody. Apparently about a month ago, Traconis went in and bought a new SUV and paid cash for it. And, she's not working. I'm not sure she would pay cash for that, $50,000 in cash. Maybe it's a little hush money. I don't want to spread rumors or anything like that, but it certainly makes you gotta wonder, what's going on there. I think they're going to have a tough time defending the case, just because this Doulos guy just comes across as so unlikable. Now, I want to make sure we understand he is given the presumption of innocence, and who knows, maybe he can reasonably explain why he asked an employee to remove all the seats in that Toyota. Why are his DNA and fingerprints on the bags that also had his wife's DNA on them, where they recovered them being scattered around the Connecticut area? Ugh, that's going to be a tough hurdle to overcome unless you can, explain that. And you can always say, well, he obviously was in the house and he must have touched the bags, and his wife probably cut herself cooking. And you can come up with all kinds of stuff, but let's deal with reality. You have to be able to, let's be realistic. There's all those things happening. Come on. And that's the thing, as a defense attorney, you can come up with all kinds of things, say, wasn't it probable? Yeah, but let's talk about what's really happened or could have happened, because jurors are smart people. Jurors are very, very smart, and they know when someone's trying to con them, and you can't con a jury. You got 12 people. Even if you got one or two, the other 10 are calling BS, and they're going to convince those other two. So you have to be straightforward with a jury, or you're going to get punished. Jacqueline asked, what about Doulos' attorney filing the motion to get all criminal charges dismissed? In just about every felony case, particularly a client in custody, you always get, why don't you file a motion to dismiss for lack of evidence? Well, no, you don't understand. That case is going forward. No judge is going to say, ooh, I've read the affidavit and I'm going to dismiss this case. Not going to happen. Why? Because when the detective goes to the judge, or the DA goes to the judge and says, we're asking for an arrest warrant. In that arrest warrant, they have to lay out the facts that they have to establish probable cause. And they also have to lay out exculpatory information. Exculpatory information is evidence that would reduce the guilt of a defendant. And they have to put all that in there, because if it's all completely one-sided, then there's issues related to that. But a good detective or a good DA is going to say, here's all the facts, and I got nothing to hide, okay? A judge signs the affidavit for arrest warrant, it is granted. If they go to a grand jury and they indict, then they have an indictment, but the same general process. If they proceed via complaint and information, then they're usually titled to a preliminary hearing. A preliminary hearing is a screening device to determine if probable cause exists. So what happens? The detective, usually the detective that got up and or gets up on the witness stand, who's the same detective that went to the judge to file the affidavit, it's the lead detective, and he regurgitates what's in the affidavit for the arrest warrant, and probable cause is found. The judge is not going to dismiss the charges unless they failed to present some evidence to each and every element of the charge. And it's, like I said, it's a very low standard of proof. For lack of a better term, the easiest way to explain it is the judge has to view the evidence in the light most favorable to the prosecution, drawing all inferences in their favor, which basically means they have to treat the allegations as true, okay? Even if you go to motions and you say, oh, you need to dismiss, the judge is going to say, it's not my job to substitute the jury. It's the prosecution's case. They can present the evidence, and if they have enough evidence, they'll achieve a conviction, and if not, they will lose. Bottom line. Only if at trial, if the government fails to submit some evidence to each and every element of the charge that they have charged, then the defense can move for a motion for judgment of acquittal on those counts. I've had that happen sometimes where the district attorney forgets to present some evidence that they have to establish, because each charge has elements, and that it was occurring on this date, that they believe the defendant had something to do with it. Their knowing element, that they intended to cause something to happen that actually happened. But if they forget to do that, or they forget to say where it took place in the state to establish venue, you can move for a motion for judgment of acquittal, but not until then. And even then, most judges are going to say they presented some evidence, and that's it. And even if they really screwed up, the judge would usually allow them to reopen their case so they can present some evidence, and it's going to go to the jury. Most judges are not going to throw cases out. They're going to leave it to the hands of the jury, because they'll say, it's not my job to be the 13th juror here, and basically override their decision. So attorneys saying we're going to file a motion to dismiss. You can file a motion to dismiss all day long. You can file a motion to dismiss every day, and it's going to be denied. That is attorney blustering on the part of Doulos' attorney. So, hopefully that explains that process. We hope so. Let's see here. I can't even learn. You having. Let's see here. Yeah, Doulos is out. $6 million bond. I mean, I'm not sure where all of his resources are coming from, but Doulos, like I said, $6 million. That's most people can't make that. Most capital cases, people are held without bond. So the fact that they even set it that high, and that he made it at some point, and I'm not going to profess to know Connecticut law off the top of my head here, but at some point they could have a hearing which would require him to remain in custody. Where I practice, and everywhere I've practiced, if you're charged with first-degree murder, you're sitting in custody. And usually the judges set the bond so high. Perhaps the judge set the bond at $6 million, thinking he wouldn't make it. But the attorney is the one, Mahini, Doulos' attorney Mahini. Like I said, he's the one that remains in custody. And my gosh, it's not even his wife. And all of a sudden he's charged and he's sitting in custody. Man. But I love how the reports were that this guy was literally at court and they're trying to arrest him. And he found out that there was an arrest warrant. So he had his secretary call the court, and he had just left, and he was across the street at another courthouse. And they were literally like 2 steps behind him along the way. Scott, with the resources Doulos had, would he be able to buy himself a fancy defense? Oh, yes. He is going to, if you can make a $6 million bond, you can get out. You can, you can hire experts. You can do what you need to do. And the beautiful thing with, when people have that kind of resources, kind of a joke, but, justice is expensive. Injustice costs a hell of a lot more. It's true. You can do a lot with $6 million. I assure you that. And you can come up with lots of theories and lots of experts and try to create some reasonable doubts. So we'll see. Let's see another question here. Long time belief she is innocent. Darlene Routier case. She's on death row, and I've been into this case a long time, and I believe she's innocent. I'm sorry, I don't know enough about that case to comment. Scott, love your show. What's the most bizarre, interesting case you've handled as a defense attorney? Ooh. Wow. Yeah, can you pick just one? I mean, there's been so many, and I'll try to keep it general so I don't do anything, but let's just say one time I had a client that was accused of a crime, and his girlfriend, who was substantially older than him, was married, or they were in the process of a divorce, and the children made an allegation against my client for doing something inappropriate. He was arrested. The father of the children gets so upset with the mother for allowing new guy to be around, he actually shoots mom. Crazy, right? So that gentleman's then charged with murder. As the case goes on and it develops and what have you, the young woman ultimately recants and states that she made everything up as it relates to new boyfriend of mother because she didn't like him and was hoping mom and dad were going to get back together again. So obviously my client gets cleared, and then in the meantime, the guy that's in custody for killing his wife, based upon these allegations that were false, that my client had sexually assaulted him, he's in custody, and then he ultimately commits suicide in jail awaiting trial. And I mean, it's just a tragic story because, one, there was a false allegation that was made, but yet everything that led from that resulted in, this young lady's complete family being destroyed. So I guess the moral of that story is don't lie. I mean, the truth in an adversarial process, the truth will come out. I mean, when you have a witness that's on a witness stand that says, the sky is blue right now, and you have somebody cross-examine and say, well, actually, no, it's gray. Let's go take a look outside. The truth is going to come out versus somebody just saying, I know everything. This is the truth. If you can't, it's like life. If people just accept everything at face value from somebody, no, you need to be skeptical of everything and everybody. You have to question it. No one has the absolute truth, but usually you can find it, and the truth is usually somewhere in between, and you find it during an adversarial process. And that is the good thing about, about our adversarial system. Let's see. Greg Banks. Hey, Scott, from the UK. Have you ever got anyone off that really should not have? Yes. Yes, it happens. But, and I've discussed this before. If somebody is found not guilty, it's not the defense that's, pulled something shady. The prosecution failed to prove their case beyond a reasonable doubt. And that's the way our system is set up to work. And if the prosecution doesn't do it, that's justice. That's our justice system. There's, it's brought up a lot, in courts, that our system is based upon the notion that it's better for 10 guilty men to go free than to convict one innocent man. And that's the way the system works. But yeah, I've had lots of clients that, you lose and you want to go home and take a shower with a wire brush to, get that terrible feeling off of you. But that's the way the system works. The person's only guilty if the prosecution proves it. Some people may not like that, but that's just the way it just works. Let's see here, and lots of people, are always offended by that. I remember my mother-in-law used to always ask, how can you represent those people? Well, it's easy. I mean, they come in, they hire you. You want to make sure that you represent them zealously. And as a defense attorney, or any kind of attorney, when you take your oath to support and to defend the Constitution, that's what you do. You're defending the constitutional rights of these people. And if anyone was ever charged with a crime, and I would guarantee you that throughout your life, hopefully it'll never be you, but if you have a family member or a friend, somebody will be charged with a crime. And hopefully it's nothing serious, but it could be something as simple as, maybe a DUI. Even a traffic ticket is basically accused of a crime. Maybe you did it, maybe you didn't. Even when you get a traffic ticket, Do you go in there and say, hey, give me the full 4 points, I really deserve it? Or do you go in there and you try to negotiate it down to that 2-point defective vehicle? I mean, think about it. That's what the process is about. And they still have to prove that speeding ticket by proof beyond a reasonable doubt. But you don't want to tell me, but let me tell you about a crime, all right? And this is a crime that I have been accused of. Yes. And it's a stupid law, and stupid laws need to be ignored, all right? And that is not having a front license plate. Now, the lovely Miss Kristen joined us here today in the studio, and she's over here laughing because she thinks this is ridiculous. But there are certain cars that are not made to have a front license plate mounted on it. In particular, my new car. And you can't drill in. It would be a crime to drill in to put a license plate on an M5 BMW. And I'm not doing that to brag. I'm just saying it would be a crime to do that. And Denver has the dumbest law where if you don't, Colorado has the dumbest law, if you don't display your front license plate and you get a ticket, it's $125. Well, I guarantee you, I will fight this. I will fight this to the highest court in the land. This is outrageous. It's a travesty of a mockery of a sham. I will not stand for it. How many jury trials? I'll keep you updated on the license plate thing, too. Maybe I'll videotape my license plate hearing. I'm going to go in and fight it. I'll have the office working on a motion to dismiss immediately. Question, how many trials have I done? What's my win rate? I don't know the exact number of trials that I have done. Years ago when I first started out, I kept a little logbook of them. And I don't know why. I think somebody told me, keep track of those. You never know, blah, blah, blah. And now I don't know. I've probably 12. Do the math. Probably 400 jury trials, I would say. And, maybe another couple hundred trials to the court, not to mention all the cases that are resolved short of trial. I think I've done a pretty good job. We've won some really, really bad cases. And we've won federal drug conspiracy cases. We've won murder cases, racketeering cases, sex crime cases. We've won a lot of them. We've lost trials too. And if any attorney tells you they've never lost a trial, it means they're not taking the tough cases. And sometimes you have to look at it, not necessarily as a win, as a not guilty all the way. We've had cases where there's been no offer, and we said, hey, my client is charged with, murder. What it really is negligent homicide. Why don't you offer as negligent homicide? We'll take that plea. And they say no, the government says no, and then we go to trial, and we get a negligent homicide, which is what the client always wanted, which is what we always said they were guilty of, which is what they would plead guilty to. So, did we win? In the eyes of my client, we won. I think we won. When you beat the offer from the district attorney, you win. So, it just depends. And, I will be the first one to tell you, I have won trials that I should have lost, and I've lost some that I thought we were pretty close and we were in the game on, but it just didn't turn out. Probably didn't pick a very good jury. Maybe I asked the wrong question or something. You just never know. Scott, federal cases have a 95% conviction rate. Yes, they do. And the difference between the state and the federal court system is a lot different. The state cases usually fall in their lap. There's a crime that's committed. The police will go and investigate and they prosecute it. The federal cases are more, the U.S. attorneys are more working with law enforcement, and they build cases over time. And they have to be bigger cases because federal cases have to involve interstate compact or interstate nexus to establish federal jurisdiction. It isn't a federal crime just because they say it is. There has to be something that takes place either on a federal institution, reservation, or there's a crossing of state lines for that to take place. I've won cases in federal court. I've won counterfeiting cases, drug cases, and I've lost some too. We do lots of guns and drug trials in federal court. We did one a while back where we won some counts and we lost on others, but overall it was still a victory considering there was no offer. Here's a good question. Scott, what's the most damning piece of evidence in the Frazee trial to get that guilty verdict in your eyes? It's clearly, in my position, was that the jury obviously believed the new girlfriend, which was Crystal Lee Kenny, the nurse. They obviously believed that she witnessed and participated in the disposal and destruction of the body in that particular case. And, that was it. They don't have a body, but they believed her that they saw her dead. And even though they didn't find the remains, and there was some evidence that the body had been burned out at that ranch, Frazee's mother's ranch, that's what juries can believe. The fact that there was burned plastic out there, I don't know. I was a little surprised. I'm not going to criticize the defense. I don't know what they had to do with. And I take that back. The other thing that really hurt Frazee was that his jailhouse letters to a jailhouse snitch, basically trying to have key witnesses killed, or at least talking about it. That shows consciousness of guilt. If he was writing letters saying, I can't wait for my day in trial, I did nothing wrong, I have nothing to do with it, that's a good letter. Prosecution probably not going to introduce that. But when you write letters saying, hey, I'll pay you X amount of dollars to go kill the key witness in my case, you're lucky you don't get charged with a conspiracy to commit murder or, witness tampering on top of it. They're probably not going to prosecute him for that simply because he's serving life without parole. But that is clearly, something that did Mr. Frazee in. Consciousness of guilt, flight. If, it seems like I always get, particularly on homicide clients, my clients always wind up in a different state. Suddenly they had this great urge to go see a family member who was sick in, whatever state. Coincidentally, they also happen to know that they were the suspect in a homicide case. Flight shows consciousness of guilt. There's actually an instruction that says you may consider that when people leave the scene, so to speak. And just because you stick around doesn't mean you're not acting guilty as well when you start writing letters. So we'll see. And even on the Doulos case, there'll be something. He's gonna mess up. The guy's he's just a little too cocky going on news media and things like that. The guy should simply be keeping his mouth shut. He doesn't need to try his case in the court of public opinion because it doesn't matter. The only thing that matters are those 12 jurors that decide his case. Here's a question. Scott, what made you choose the defense attorney route? What was it the challenge? Good question. So, in all honesty, for lots of reasons, I didn't think I was ever going to ever do criminal defense work. It had no desire to me whatsoever. When I was in law school, I worked for a firm that did civil litigation and a lot of corporate transactional work. And when I got done with school, because I was literally working full time, going to law school, my son was born the last year of school, and I was just so tired and burned out. And then I knew I wanted to do litigation of some type, and the attorneys were like, well, maybe in 5 years you'll be able to handle your cases. And so when I heard that, I was like, I can't sit around and write memos and do research for the next 5 years. I want to go do something. So I'd previously been in the military, and basically I called the Marine Corps back up and said, hey, you guys need any attorneys? I'm going to be an attorney. So yes, I had to go back through, do officer candidate school all over again. In the Marine Corps, everybody is a line officer, so you go do the 12 weeks of officer candidate school. You get commissioned. You go do 6 months at the basic school, which is basically 6 months of infantry officer for every Marine Corps officer. because like I said, every officer is a line officer. So if you're an attorney, a pilot, you're all basically an infantry platoon commander as well. So then I did that. I go to my first duty station. I didn't know what I wanted to do, really. I knew I wanted to do litigation. And I show up and I get stationed at Parris Island, South Carolina. And they're like, what do you want to do? I'm like, well, I think I want to be a prosecutor. And they're like, oh, you're going to be a defense attorney. And I was there with a friend of mine that we'd gone through the basic school and naval justice school together. He's like, I think I want to be a defense attorney. And he's like, great, you're a prosecutor. And so we did that, and then we switched after a time. But I just really liked the litigation aspect of it. And I love being in the courtroom. And I've said this before. Anybody can be a lawyer, okay? Anybody can go to law school. It takes a certain breed to do like litigation, but that's not really trial work. And then there's the difference of, actually going to trial. And not everybody can do that. It is a situation where most people will learn rather quickly if they're thrown into a trial situation, whether they're any good at it. And a lot of people simply aren't. And a lot of people quickly realize, I don't want to be in a courtroom. I'll write motions, I'll write briefs, but by God, don't put me in front of a jury. You'd be surprised how many attorneys have anxiety in front of juries. It's amazing. It's like, why are you doing this trial work? Well, I don't like it. They make me. I like it. It doesn't bother me at all. But you have to really be able to think on your feet rather quickly in a trial situation. You've got your client sitting next to you who's usually trying to jabber in your ear. You have the situation where you have everybody watching you in the courtroom. The jury is looking at everything you do, everything your client does. And so in that time, you have to basically know the facts of your case. And that's the biggest thing. You have to know the facts of your case, because when those questions are asked by the prosecutor in that brief second, you have to anticipate the full question, listen to it, quickly process, is this good? Is it objectionable? Even if it is objectionable, is it good for me tactically? Tactically, should I not object to it, but I need to preserve my record if there is a conviction so that, it's an appellate issue? And that all takes place within a matter of seconds. And normally what you think is going to take place in trial, as soon as the first question is asked, the first witness is called, something changes. Maybe the witness doesn't show up. They change their story once they've thought about it. It's amazing. You can talk to people before the trial, talk to them, interview them, and they get to court. And it's not saying that when they take that oath that's a some sort of truth serum or chair, but when they get a bunch of people looking at them, it's nervous, and you have to actually listen and answer the question. You never know what they're going to say. You really don't. So what I liked that's how I became doing defense work, is basically in the Marine Corps. I loved it. It was fun. It was a lot of fun. When I got out, I looked at other places to hire. I actually interviewed, or I couldn't get an interview at the time when I got out with a DA's office, the United States Attorney's office. So I hung up my own shingle. And I remember interviewing for a couple of firms, and they're like, wow, you have more trial experience than some of our trial attorneys. Because, I was trying cases for the last, 4 years in the Marine Corps. A couple trials a month. And you practice it, you do it, and then you have a little bit of success, and people start hiring, and next thing you know, here you are 25 years later, 20 years in private practice, and doing it. So it's, it's fun. It's exhausting some days. The clients wear you out sometimes, but most clients are very good people. They just are very scared of the circumstances that they have found themselves in, and they're very nervous. But it's that 10% rule. Like most things in life, you spend 90% of your time on 10% of the clients that they've never gone through anything like this, and they need to be reassured that everything is going to be okay. But when you hire us, we do the worrying so that you don't have to, and you can relax, and we'll tell you when to worry, if ever. And hopefully you don't have to worry, because we'll make things good again. Scott, do you support businesses that don't support open or concealed carry? I don't really care if a business says concealed carry. I mean, I have a concealed carry. Do I carry a firearm with me all the time? No. Why? Because I'm in and out of buildings all day where you can't take them in. And I don't want to leave it in the car. So most of the time, don't have one at all. But if it's, I'm not going to say, oh, somebody has the little gun thing up, don't go in. That's their decision to make. And I guess if somebody doesn't want to support it, or they do want to support it, that's their decision. I'm not going to, if they have a good product, then I'm simply going to go there, whether they allow guns or not. And hopefully there's no need for it, but you never know. That case down in Texas, man, that guy was a good shot. Man, that was a good shot. Scott, what are your thoughts on the Steven Avery case? Wow, the Steven Avery case, made for good TV, that's for sure. But, jury found him guilty, and, it's been, reversed, not reversed. I don't think he's going to get out of that particular case this time. I just don't see it. I don't think it's going to happen, but I could be wrong. I don't know. Marion, what do you do to relax? Well, like today, for example, I'm trying to convince the lovely Miss Kristen that she should let me fly her somewhere to take her to lunch, because that relaxes me, because you can only focus upon flying, and you can always relax by having a fine cigar. That is the most relaxing thing, and some of my best ideas have come while I've been smoking a cigar. There's just something truly, truly relaxing about that. Let's see here. Thanks for answering, Kathy. Let's see here. Oh, can you practice in other states? Well, it depends. So, for example, in most federal courts, you can practice. If you're licensed in one state, you can seek admittance in that particular jurisdiction. Sometimes you have to have local counsel, but that's okay. Now, with other states, and I've been hired, I've done cases all over the country. We just finished one in New Mexico. We've done Wyoming, South Dakota. We did the Middle District of Pennsylvania a while back. Have some investigations going on right now in federal cases all over the country, and if something happens, then we'll deal with that. But yes, I can be retained and handle cases in other states, but usually have to have a local attorney be on the case with you, and that you have to be admitted what they call pro hoc vice, and that's basically you're admitted to practice law for that particular case with limited, admittance for that particular matter. And then you, but as I tell clients, and I've had clients that, hey, I want to hire you for my brother's case. And I have to tell them, we just finished a case in South Carolina. We had another case where somebody inquired about a case in South Carolina. I was like, I'll go anywhere. But understand it's going to cost you a lot more money, because you basically have to hire two attorneys, me and local counsel, and I've got to travel to get back and forth. So, if you have dollars, we'll travel, but it's usually not expensive, and there's great attorneys everywhere in every state. And I'm not so naive to think that I'm the greatest attorney, or that nobody could do it without me. So. Let's see here. Ooh, if I could interview anyone, who would that be? Ooh, let me think about that one. We'll come back to that. Let's see here. Because I make an accusation. Yeah. Do you have any famous cases, Scott? Do you have a famous case that intrigues you? A famous case that intrigues me. I mean, there's so many interesting cases out there. I mean, there really are. I mean, I really think, and not to get too sidetracked, but I think this Weinstein case is going to be interesting. I saw an interview with his attorney the other day, and they're clearly going a complete consensual route right now, saying that it was all consensual, that these women wanted something from Harvey Weinstein and he wanted something from them. They wanted to advance their careers, and you're not going to Mr. Weinstein's room at 10:30 midnight after you've all been meeting and drinking in a bar, because you're not going there to discuss the next day's schedule. And so basically they're going to say these women wanted something from him and he wanted something from them. And basically, for lack of a better term, it was transactional in nature. I'm not sure that that'll carry the day, but I guess that's probably, that's their defense and they're going to run with it. I got some pretty strong feelings like that. My first thing is old Mr. Weinstein never should have put himself in that position. If he wanted to discuss their future careers, you should probably come to the office between the hours of 8 and 5 and leave your door open, and maybe have your assistant in there as well, so there's no hanky-panky allegations going on. There's no casting couch. This is the 21st century, for God's sakes. And I'm not trying to shame anybody, but let's face it, if some guy asks a woman to come back to his room after they've been at the bar drinking, one could probably assume that he's going to try and do something, whether he's married or not. So as I try to tell my clients and people that I try to keep from ever being my clients, is do not put yourself in a situation that is bad. Ask yourself, how is this going to look? Remember when people tell you, how is this email or letter going to look on the front page of the major newspaper in town if I have to explain myself? How's it going to look if it gets out? Same thing. How are you going to explain this to your wife, your family, your friends, that you're in this situation with some woman at your hotel room, going on? So I don't know. I mean, frankly, after hearing the attorney for Weinstein, I didn't think he had a shot, and maybe he still doesn't. But there's something about having a female attorney that can cross-examine these victims in a way that's kind of woman to woman. Like, really, did you really think this was just going to be, talking business? Where maybe as a guy, it would come across as some sort of victim shaming. So I don't know. I don't know much about the attorney, but she impressed me, and we'll see how things go. I think Weinstein will be his own worst enemy. And, I think somebody said, for God's sakes, look at the guy. It's not like he was some, beach model, so to speak, epitome of, fitness and good looks. Like, come on. I mean, it was either consensual on their part, or it was absolute rape. I mean, that's what juries decide. So we'll see. Oh yeah, he's trying to change his look. Yeah, the whole sympathy thing with the walker, that's not going to work. He needs to go in there confident. He needs to walk in there. I guess he just had back surgery, so if he needs a walker, so be it. But seeking pity from a jury, that never works. You need to go in there and be confident because you are right and you are correct. And if you're the defendant, you want them to correct an injustice. And when you think that when you're the prosecutor, you're in there saying we're doing justice. So sympathy doesn't work. Juries are smart. I've said it before. They'll think they'll do it again. They can't be BS'd. Oh, let's see here. Let's see here. Someone watched your channel, was impressed by what they saw or heard. Have you got a case because someone watched my channel? Yes, but most of our cases these days still come from referral. So we really like that. That's the best. All right, what are we? Right about an hour. All right. Let's see if there's any questions here that I didn't. Well, there's lots that I didn't get to, but let's see. It's normal in such serious matter. My question is in the Teresa Seavers murder trial, particularly Jimmy Rogers, he pleaded not guilty, yet called no defense witnesses and didn't testify himself. Why plead not guilty and have only the cross-examination closing arguments be your defense? Is this normal in serious cases? Yes, happens all the time. In fact, I've won more cases where the defense calls no witnesses and the defendant doesn't testify. Happens all the time. So you have to remember, the prosecution has to prove their case beyond a reasonable doubt. The burden always remains with them to prove guilt. The defendant never has to prove his innocence. If you think that the case is weak, or maybe you just don't have any other witnesses, and guess what? When you call a witness, what they testify to is evidence that's coming in. And if those questions come from the defense attorney and the answers are evidence as well, we're not going to just have the prosecution ask their questions, leave, and then have the defense call them back in their case in chief. So when they're asking questions, they're actually presenting, for lack of a better term, a defense, but it's just coming out in the prosecution's case in chief. So they may have got all the information that they needed from the witnesses that were called by the prosecution. I've won more cases, even when I believed my client was absolutely innocent, when he doesn't testify. Because when you testify, you say things, and the more you say, the more likely you could say something wrong or inappropriate or doesn't come across well. Sometimes witnesses are terrified to testify. I talked about anxiety. What is the greatest fear of most people? Public speaking, okay? It's actually a greater fear than death in one survey that I saw. So think about it. Some people get nervous. They don't handle things well in public, even if it's, just a courtroom full of people, a jury, a judge, a court reporter, a prosecutor. That's a big deal. Some people, they can't do it. And then when you call the defendant in a particular case, it then shifts from looking at the evidence or the lack thereof to really, do we believe what the defendant had to say? And, a lot of people are like, I knew he had beady little eyes. I didn't like it. I didn't like him at all. And they'll completely ignore the evidence. But when judge gives an instruction that says you can't consider the silence of the defendant, jurors are going to follow that. And they're going to say we have to make our decision of guilt or not guilty based upon the evidence or the lack thereof. So when a defendant doesn't call any witnesses, maybe they didn't have to because all the witnesses were called by the prosecution. They got to cross-examine. They got their questions answered. And then the defendant never has to testify. Why would you, unless you absolutely you need them to present some evidence so that you can put to get a particular jury instruction. Frankly, it's always better to do it if you can have your client not testify. So that is a routine question. Hoping that answers your question, Karen. All right. I think that's all we have. Let's see. Do you send out funny law-themed Christmas cards? My boss always does, and everyone enjoys them. This year, I got to choose for the firm. No, we don't send out funny law-themed Christmas cards. We probably should, though. That's a good idea. We always send out the generic happy holiday Christmas cards. But it used to be a big deal, but now nobody sends Christmas cards. I remember you used to get a stack of Christmas cards, and you used to send out hundreds of Christmas cards to everybody. And now it just seems like nobody sends out Christmas cards anymore. Probably because, what? Oh, the big question. What? Oh, yeah. If there's anyone that you could interview, who would it be? No. This guy right here. That's great. Lieutenant General Chesty Puller. Obviously, he's dead. But one of the greatest Marines that ever lived. Could you imagine the war stories that guy could tell? World War II, Frozen Chosen. I mean, the man is a war fighter. He is a leader. When surrounded by the North Korean troops at the Chosen Reservoir, he's basically said, perfect. We've got him right where we want him. And they cut through and they lived to tell another day. I'm telling you, Chesty Puller, greatest Marine ever. That's That's who I'd probably want to interview. On the legal side, the person I would want to interview on the legal side, if he was still around, would be Justice Antonin Scalia. I've heard him speak. I read his books, and just his legal analysis is of that of an originalist. The words mean what they say what they mean, and you don't change them. And if there's an interpretation as to what they mean, it's based upon at the time that they were written. That's the way documents are meant to be interpreted. The Constitution's meant to be that way. And, you know, I remember him speaking, and it was the First Amendment case. It was the flag burning case down in Texas, where it was a law to burn the American flag. And he said if it was a 5-4 plurality decision, and do you know who the deciding vote was for saying that it was okay to burn the American flag, that was the ultimate expression of political speech? It was Justice Scalia. And he went back to the Constitution and said, at that time, that would be the ultimate freedom of political speech. He hated it. He deplored it. But that's what the law said. And he always said, and I think it makes great sense, and I always cite this in briefs when I need a judge to make a tough decision, because he basically says, if you are a judge and you get to the decision that you want every time, you're not following the law, because the law is not always going to be what you want. And in that particular case, he followed the law as a judge should do, not to make up his law, not to do what he wanted to do, but to follow the law. If you don't like the law, there's only one person that can change it, and it shouldn't be the courts, it's the legislature. And they, I assure you, can write some very, very bad laws. And the reason why lawyers are in such abundance and there's always such work, one reason, ladies and gentlemen, one reason: poorly written laws. You want to know why those cases that you hate to hear about that get reversed? Poorly written laws. The legislature are the one to blame. They don't read the stuff. They have special interest groups feed them the laws. They don't care. They don't do it. They hold a little hearing. They perfunctory go through the motions, and they don't ask the people that are actually going to do it on a daily basis. So you don't like the laws. You don't like the case where the guy gets away. Don't blame the lawyers. Don't blame the legal system. Go blame the legislature who drafted the poorly written laws. So, all right. Time to go flying. Going to go into Crime Talk 1. Take the lovely Miss Kristen, to lunch somewhere. So have a great day. Thanks for tuning in. If you haven't done so already, please subscribe. We do appreciate it. We do appreciate you tuning in. We understand that there are lots of things that you could be doing, and the fact that you take the time to listen to our little channel is greatly appreciated, and it does not go unnoticed. And for that, we say thank you. Have a great day.